January 31, 1976, downtown Phoenix. The Amapala Bar. A 34-year-old man lies bleeding on a barroom floor, stabbed during a fight over a card game. In his pocket, police find several laminated cards. Cards that every police officer in America now carries. Cards bearing his name. The suspect read his Miranda rights, and then silence. He exercised his right to remain silent. The man on the floor, Ernesto Miranda. The same Ernesto Miranda whose name is on those cards. The man who changed American justice forever. Died because someone used the rights he created. But this story doesn't start with his death. It starts 13 years earlier. March 13, 1963. Phoenix, Arizona. Ernesto Arturo Miranda was 22 years old. Mexican immigrant, 8th grade dropout. A life marked by petty crimes, reform schools, and bad decisions. He'd been arrested before for theft, for robbery. He was, by most accounts, a troubled man trying to survive in a tough part of Phoenix. 10 days earlier, an 18-year-old woman had been kidnapped and sexually assaulted after leaving her job at a movie theater. She gave police a description of her attacker and his car. A partial license plate, green or grey sedan with distinctive upholstery. On March 13th, police arrested Miranda based on circumstantial evidence. They brought him to the station, put him in a lineup. The victim couldn't positively identify him, but what happened next would change everything. Two detectives, Carol Cooley and Wilfred Young, took Miranda into an interrogation room. No lawyer, no warning about his rights. Just Miranda, alone, in a room with two experienced interrogators. 2 hours later, Miranda signed a written confession. At the top of the form, printed text stated his confession was made knowingly and voluntarily. But here's what that form didn't say. Miranda had the right to remain silent. That anything he said could be used against him in court. That he had the right to an attorney. That if he couldn't afford one, the state would provide one. Nobody told him any of that, because in 1963, they didn't have to. Miranda's trial was swift. June 27, 1963, his defense attorney, Alvin Moore, objected to the confession being admitted as evidence. He argued it was obtained improperly, that Miranda didn't understand his constitutional rights. The judge overruled the objection. Miranda was convicted of kidnapping and rape, sentenced to 20 to 30 years in prison, based almost entirely on that confession. But Moore appealed to the Arizona Supreme Court. They upheld the conviction. The system, it seemed, was done with Ernesto Miranda. Except, it wasn't. Filing as a pauper, meaning he had no money, Miranda submitted a petition to the United States Supreme Court in June 1965. By this time, the American Civil Liberties Union had taken notice. They assigned the case to John J. Flynn and John P. Frank, prominent criminal defense attorneys at the Phoenix law firm Lewis and Roker. The right to not be forced to testify against yourself. And in November 1965, the Supreme Court agreed to hear the case. But here's the thing, Miranda wasn't alone. The court bundled his case with 3 others: Vignera v. New York, Westover v. United States, and California v. Stewart. All involved confessions obtained without suspects being informed of their rights. The question before the court: could police interrogate suspects without telling them they could refuse to answer? Without telling them they could have a lawyer? February 28th, March 1st and 2nd, 1966. Oral arguments before the Supreme Court. On one side, Miranda's attorneys argued that the Fifth Amendment's protection against self-incrimination meant nothing if suspects didn't even know they had rights. That the intimidating atmosphere of police interrogation created inherent coercion. On the other side, Gary Nelson, representing Arizona, argued this wasn't about the Fifth Amendment at all. He warned the justices that requiring police to inform suspects of their rights would seriously obstruct public safety, that criminals would go free. Even Thurgood Marshall, the legendary civil rights attorney serving as Solicitor General, argued the government simply didn't have the resources to provide attorneys to every person accused of a crime. The court went back to study police training manuals. They examined the history of coerced confessions. They looked at cases stretching back to the English Star Chamber of the 1600s, where torture and intimidation were common. And on June 13, 1966, Chief Justice Earl Warren delivered the opinion, 5-4. The court ruled in Miranda's favor. Warren's opinion was clear because of the inherently coercive nature of custodial interrogation. No confession could be used in court unless the suspect had been informed of specific rights and had voluntarily waived them. The rights that must be stated: you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Police departments across America immediately began printing wallet-sized cards with these warnings. They called it Mirandizing a suspect. The dissent was fierce. Justice Byron White wrote a scathing opinion, warning that in some unknown number of cases, the court's rule will return a killer, a rapist or other criminal to the streets. Critics called it judicial activism. Police unions protested. Prosecutors predicted chaos. But the decision stood. As for Ernesto Miranda, the Supreme Court overturned his conviction. But that didn't set him free. Arizona retried him in February 1967. This time, his confession wasn't allowed as evidence, but prosecutors found another witness. Miranda's common-law wife, Twyla Hoffman, testified that he had confessed the crime to her when she visited him in prison back in 1963. The jury deliberated for 1 hour and 23 minutes. Guilty again. 20 to 30 years. Again, Miranda served 11 years. He was paroled in December 1972. And here's where the story gets strange. Ernesto Miranda became a minor celebrity in Phoenix. He made money by signing Miranda warning cards, the very cards bearing the rights he helped create, and selling them to police officers and lawyers for $1.50 each. He'd show up at bars, autograph cards, tell his story, a footnote in legal history, trying to make a living off his own name. But his troubles weren't over. He violated parole and went back to prison for another year. He worked as a delivery driver after his release. Minor arrests, traffic violations. The pattern continued, which brings us back to January 31st, 1976. The Amapala Bar, a card game, a fight over $2 in change. Ernesto Miranda was stabbed. He was pronounced dead on arrival at Good Samaritan Medical Center. He was 34 years old. Police arrested a suspect. The man suspected of handing the knife to Miranda's killer. The police read him his rights. You have the right to remain silent. And he remained silent. The suspect was released. There was never a conviction in Ernesto Miranda's murder. The killer fled and was never found. The man whose name became synonymous with criminal rights died because someone exercised those very rights. The Miranda warning created to protect the accused protected the man suspected of killing Miranda. Today, over 60 years later, the Miranda warning is one of the most recognized legal phrases in American culture. More Americans can recite Miranda rights than can name all the amendments in the Bill of Rights. It's been challenged, refined, narrowed in scope, but in 2000, in Dickerson v. United States, Chief Justice William Rehnquist wrote that Miranda warnings have become part of our national culture. Ernesto Miranda was far from a hero. He was convicted twice of serious crimes, but the case that bears his name stands for something larger than one man's guilt or innocence. It stands for the principle that even in the pursuit of justice, the government must respect fundamental rights, that the vulnerable, the uneducated, the scared, they deserve to know they can remain silent, that they can have a lawyer. The irony of Miranda's death, killed while someone exercised the rights he helped create, is a reminder that rights cut both ways. They protect the guilty and the innocent alike. And that's exactly the point. Every time a police officer reads those rights, they're invoking the name of a man who never finished 8th grade, who died in a barroom brawl, whose killer walked free using the protection Miranda gave them. Justice isn't always neat. History isn't always fair. But rights, real rights, they endure.